Hi, in this video I'm going to talk about a will. I have taken just a will scenario and trying to give out some important points. This is a community group discussion. For any particular requirements that belongs to you, you should talk with your own attorney. Okay. Alright, so now property classification. In the property classification, there are so many important points that your attorney and state laws will decide. So first thing is how the asset is structured, means is it a community property or is it bought by your separate funds. All that is involved, and top of it there are Heir classifications. So based on that there are so many variations. Your attorney exactly knows how to do it, and your state law also defines it. And in general it's a tangible property. The tangible property is the furniture, equipment, vehicles, household goods, real estate, collectibles, jewelry, and other etc. Okay. In the intangible property, bank accounts, stock, bonds, insurance policies, retirement benefit accounts, intellectual property, patents, copyrights, trademarks, trade names, and other etc. These are all intangible property. Okay. So what is an intestate versus testate? So any particular individual, if he passed away without a will, that is called as intestate, and he's called as a decedent. And if he is having a will, then it is called as a testate. So intestate means passed away without a will. So interstate probate. Okay. So after the decedent passed away, the properties will be going through the probate process. So involvement of probate lawyer will be there. That's a cost involved. And first thing, they will determine the heirs. So final application to determine heirs, and administration of the estate. Who is going to administer the estate? Okay. So there are two types of administration that the court will decide. Okay, whether it's going to be independent administration or a dependent administration of the estate. So there is not much you can do here. The court will decide. Oh, it's going to be independent administration or a dependent administration. Okay. So intestate, in the dependent administration, and why it is given to you, given to the executor, and given why this option is selected by the court, by the judge of the court. There are few things that if the heirs were not agreeing on who is going to administer, and if the minor was involved, then the judge and the court will act in the best interest of the minor, so they want to control. And the third is if it is too complex. It means if there is too many debts involved, if there is too much property involved, then it's going to be a dependent estate administration. Okay. So for this, the administrator, who is selected for the administrative process, has to take the court approval for any activity related to the assets. Okay. So without court approval he cannot do anything. Okay. On top of it, the judge will appoint ad litem, an attorney, which is called as ad litem. That's another cost involved. The ad litem is basically he is going to identify all of the other factors that's going to affect and make sure everything is going in a right way. That's what he does. That's the cost involved. And after that, the hearings on the application will happen, and once it was done, the control and management of estate assets will be given. Okay. So what about the dependency? What about the independent? In the independent administration, yes, the court has given the approval for independent administration. That means that he has given some rights that he doesn't have to come for the court approval for, if it is done in the right way according to the laws, then he doesn't have to come for a lot of activities that related to the assets. Means he has to do it in the right way, which he doesn't. For every step, he doesn't need the court approval. That's what it is. So estate assets. What are estate assets? And if it is intestacy, and how they're going to identify what kind of assets belong to that estate. Okay, decedent estate. So the intangible assets with beneficiary designations are passed directly to the beneficiary upon death of descendant. So any intangible assets which has beneficiary designations are passed to the beneficiaries, and decedent owned assets without a beneficiary designation or a survivorship arrangement is included in the estate, is included in the descendant estate. If survivor arrangement was not done, or no beneficiary designation, even if it is an intangible asset, then basically that asset is included in the decedent estate. So what you should do, so what should you think of immediately? So immediately you should update whenever, if the live person should update his beneficiary designations in all of the assets wherever possible. So to do what? To avoid probate. Okay. So, but you should remember the fact: the debt owned by decedent, whoever passed away, is paid from the assets owned by the decedent at the time of death. Means if some of the assets are in the name of the decedent, whatever debts owed by him has to be paid from the assets at the time whatever his name is attached to, even though the beneficiary designations were written. So you should know that point. So once the decedent had passed away, the living people, the beneficiaries, how they're going to take control and of the assets that were given, and how they're going to do it. For example, a bank account. For a bank account, you have to provide a death certificate, and along with the beneficiary ID, you should take the beneficiary ID, and once the beneficiary ID and the death certificate was given to the bank, they're going to do the necessary steps and give you the control of the bank account. Okay. The beneficiary takes control with the necessary steps and documentation of decedents after decedent death. So based on who is having the control of the account, they might have some necessary steps to perform. For example, if you take a life insurance policy, the life insurance policy, a death certificate has to be provided along with some of the application process. Once the application process has been completed with the death certificate attached to it, they're going to release the proceeds, okay, to the beneficiary. But if you call them and ask who is the beneficiary, they're not going to say it, But if you know that you are the beneficiary, if you submit that application, then probably then if everything is in the way what the based on the account, then they're going to give the access. Question. Okay, now we know that decedent has been passed away. Based on after the decedent had passed away, based on the beneficiary designation, the assets are passed. What if the family member is still alive and he became disabled, and he is a bread earner, but his funds needs to be accessed by other family member because he is disabled or incapacitated? So in that case, the beneficiary will be there on the account, but he cannot access the funds. In that case, what should we do? In that case, if a statutory dual power of attorney was there, in that the verbatim says that, okay, if so and so person became disabled, any accounts that belongs to that person should be handled by a person, another individual, which is named in this statutory dual power of attorney. Okay, so that's what it meaning is. Means he can, once he became disabled or incapacitated, the other person mentioned in the attorney can do the necessary things, whatever is needed. So, and there should also be a secondary, that is the primary name, and there should also be a secondary name mentioned, because if the primary unfortunately was no more and he also passed away, but the disabled or incapacitated person is still alive, what happens in that case if the primary passed away? That's why we should mention a secondary name too. Okay, but for other scenario, this is for the accounts, right? But what if a medical scenario arrives and the family member need help on the medical scenario? So in that case, the medical power of attorney should be available, that document should be available, and advance directive should be there. Okay, in the same thing, the medical power of attorney also, the secondary, the primary and secondary should be there, and the advance directive is nothing but if something happens because a person became disabled and incapacitated, and the doctor decides that few of the things should be done or not done, he is not sure what to do at that point. So in that case, the advance directive will exactly say, while he is alive, then he writes what to do with his own body, and that will be given to the doctor such that the doctor takes necessary steps. So that's what the advance directive will do. Okay, so here we should remember proactive. What should we do to be proactive? For the easiest way to do, make sure you make a list of all accounts, policies and passwords, and keep it in a way where it can be found only if it is needed, but not like where it is available so everybody can see it. Handwrite instructions for personal items, and update beneficiary designations to accounts. That's the most important thing to avoid probate. Make sure the location of the will is known to the executor, otherwise there will be a big problem. Original will secure it in a good way. Make a copy of the will and keep it in the house in an accessible place, and if possible make one copy with executor make one copy for the executor, and keep it in a sealed envelope and pass it to him. Make sure and urge him not to open until the time is right. Okay. Then next, identify the assets that you want to pass to the beneficiary irrespective of descendant debt liability and formation, and what should be done and what kind of trust is liable to do that and what way it is best to do. All those will be, you have to talk to your attorney. So identify the areas where the estate maintenance is needed. Estate taxes, what if there is any, how it should be paid, and what is the amount going to be. Final expense costs, okay, any final taxes to be paid, okay, any kind of final taxes that should be paid by the decedent, any asset transfer cost after the decedent passed away, the assets has to be transferred to particular people. So yeah, that any transfer of assets, any cost for that, debt liabilities, okay, cash needed for the immediate needs who are living, and make sure that based on all that, make sure that enough cash is available for what? To avoid estate forced liquidation, which is nothing but fire sale. In the fire sale, most of the times the descendant property, they will lose. Most of the times it's going to be, even though the property is, the beneficiaries doesn't want to sell it, they have to because they need cash, right? So to avoid that, make sure that you identify some areas and make sure that enough cash is available. Okay. And few of the other things too I just want to talk about. In some of the scenarios where the estate is very small, the decedent estate is very small, and if only a minor or if the survivor is involved and there is no debt or very little debt, or if there is no debt and only the minor or the survivor is involved, there can be some things that can be done on the probate process, which is basically and also in that process, if, as I said, if the estate is small, only the minor or the survivor is involved and little to no debt, and if the third party, means like whoever is holding the title, agrees, then there can be some things that can be done, which I'm going to just give out the names, but these might differ based on the state. Based on the state laws, these might differ, but some of the states you can do a small estate affidavit, or these are the simplified processes that I'm talking about. Small estate affidavit or affidavit of heirship, that can be done. So, but to get more details, you have to talk with your attorney. And most of the times people think that I can do my own probate process, but it's not a good way to do it, because in the probate process there are things that has to be done in a proper way. For example, if there are any debt liabilities, then those debt liabilities has to be paid in a particular way. So if that is not paid, then some of the liabilities is going to arrive. So it's going to arise. So to to overcome all those, it's better to see your own state laws and talk with your attorney. Okay. And as I said, the same, if it is a small estate and if none to debt, no debt and stuff, there are some limitations too. You can, if a will is available in this case, that will can be in the court, you can do it as a probate will as minument of title, that can be done too. Okay. But for all these, I'm just giving you the words, you don't get confused. I think most of the things get confused, and I get confused too. I just know it can be done, but I don't know a lot of details about it. So the best thing, I'm just scratching the surface. That's it. There are too much depth, too many details involved. So to know all the details, you should talk with your attorney. Okay. Thank you, and please subscribe to my channel. See you in the next video.